What's actually in a patent? In today's video, we're going to share the essential knowledge that you need to know, dissecting the anatomy of a patent so you can better understand what it actually includes. I'm joined by Vikki, who is a chartered UK and European patent attorney and who has a huge amount more knowledge than I do on this to really help you understand the details that you need. I'm going to be sharing some real-life examples of the pushchair that I developed and patented, and hopefully this is going to bring it to life for you a little bit more.
Hi, so I'm Vikki. I work for Pure Ideas, which is an IP advisory firm. I'm a patent attorney. I've been a patent attorney for about 30 years now. I have a background in engineering and I advise primarily on patents but on other forms of IP as well.
Whether you're an inventor or an entrepreneur or a small business founder who's looking at protecting your new ideas, this video is going to provide some essential information and some top tips, so make sure you stay tuned. Let's get started. Vikki, what does a patent offer?
A patent is basically a deal between yourself and the government, and the idea is that you disclose your new innovations, which will subsequently be published. This ideally inspires others that work in the same sort of technologies to further improve upon this for the benefit of the whole of society and industry. And in return, if you're fortunate enough to get a patent granted, they will grant you a monopoly on that idea. You have to share your idea, but you get to monopolise that idea. You get to be first in the game. You can protect that concept. You can be ahead of your competitors in the market for up to 20 years. As compensation for sharing your idea.
I don't like the idea very much of sharing my idea. I know that a lot of our clients are worried about that as well. So could I share a little bit and get my patent on that, but hold back some kind of critical details of it?
It's tempting to do that for obvious reasons, because you have to publish your patent application before you actually get something granted at the end. But what can happen down the line is that your patent can be subsequently invalidated because of a lack of full disclosure in terms of how your invention works. So your patent really needs to be disclosed in a way that somebody who knows just a little bit about the technology you're dealing with is able to reproduce your invention exactly. Another thing to think about is you don't want to be too narrow in terms of how you use it, because actually by putting more detail in on more different embodiments you can apply your idea to, that can be used to argue a broader scope of protection in your consequential patent as well. So trust your patent attorney, give them all the information at the start. They will filter out what you don't need in there and make sure that we only put in what's necessary. So yeah, just be open with your attorneys and they'll guide you through it.
That makes sense. And just on that point of being open with my attorney, I know that some people I deal with are quite concerned that patent attorneys don't sign confidentiality agreements. But I understand that you don't need to, but can you tell us a little bit more about why?
Yeah, that's absolutely right. We're much like other professionals. You don't sign a confidentiality agreement with your GP or with any other kind of lawyer. So we're governed by our professional code of conduct to treat any information relating to the patent process as confidential. So it would literally be struck off and out of a job if we were to go around and share your ideas.
Okay, so I'm very safe sharing an idea with a patent attorney, because otherwise you'll lose your chartered status or you'll lose your job if you actually share it.
Yes, and I like my job, so yeah, trust me.
That makes a lot of sense. Great. And let's just go back to what you're saying about kind of scope of protection, because again, that's something that kind of comes up quite a lot. Obviously, what I don't want to do is spend a lot of time and money and effort patenting something only to find that a competitor works around it, because I'm not arrogant enough to assume that I'm the only one who's come up with a way of delivering this benefit. One of their design team might come up with a different way. So how do you as a chartered patent attorney try and avoid that being a problem?
Okay, so one thing people don't necessarily know about patent attorneys is that we all have a STEM background. So we all have, I've personally got an engineering degree, so we know a little bit about science and engineering and the technologies you're working in. And we're obviously skilled in the legal training to know that what we want to protect is a concept and not just your one sort of improvement on a particular product you've been focused on. So talk to us about what you've done. We'll ask questions about what the underlying technical problems you're solving is. Think about what other potential applications there are, discuss them with you, and we'll broaden out that general idea so that you're not losing out on that broader scope if your idea has benefits in other industries or in other products.
Oh, that's really helpful and quite reassuring. Moving on to talk about the actual patent application itself. What's in a title?
Okay, the title's interesting. If you're ever searching for patents, through the titles, you'll find a lot of them have the same title, particularly if they're from the same industry or organisation. And that is by design. So within the patenting process, very early on, the title of your patent application will be published to confirm that there's been a filing date and there's a patent application in your name. And then it's about 18 months later before the full specification is disclosed. So the idea of a very vague title is it touches on generally the subject matter that you're covering without giving anything away really about what the specific idea is, because you want to have the benefit of seeing those search and examination reports and taking a view on whether you want to continue before the full specification is published. So that's why they're all a little bit vague.
Yes, I've noticed that when you do patent searches and you find that there's, as you say, lots of things that are very similar.
Yes.
Novel pushchair or whatever.
Absolutely.
It gives you nothing, and that's by design then, it would appear.
It is, yes, there's strategy in that.
Okay. Before we talk about the background, which is the next section, I believe, of a patent application, just do take a second, hit subscribe. It does make a massive difference to the channel. Thank you. So, what is the background? What do I need to put in the background, or what do you as my attorney stick in the background section of a patent?
Okay, so quite often when you're coming up with a new idea, it's because you've looked at problems in existing technologies and you're trying to solve them, and that's what your invention does, is come up with a new solution. So what the background does is to set out what's gone before. It might talk about some of the issues with that existing technology, and then it tells a bit of a story as to where your invention's going. So you're saying, this is what's already out there, these are the problems with it, and then we can go on later to say, this is what I'm doing to solve those problems, and this is why we're getting benefits from this that you wouldn't have got from what's already out there in the background section.
Okay, that's good. And do we then go into figures, which I think is a patent term for basically drawings, or are we into claims next? I can't quite remember which one.
Okay, so in the middle of those, you would next have your statement of invention,
Okay.
which would largely reflect what's going to be the main claim at the end. So it's a broad statement of what your inventive concept is.
Okay.
You might then have a little bit of a discussion about why that solves the problems you've already explained earlier in the patent specification. And then what we go on is, as you've mentioned, to give some very specific examples of where you might apply this idea, what those sort of product designs might look like.
Okay.
You only need to have one. Ideally, you would have a few different ones, because the more variations you have in there, that can help you argue in court if you need to, the breadth of the invention that your patent protects.
Okay. So before we dissect a patent application anymore, I'm just going to pick out one bit you said there, which is probably the one word that scares most people thinking about patents, and that's court. I think very few people actually want to end up in court.
Yeah.
So if I file a patent on my idea and then someone copies it, is that inevitable then that I'm going to end up having to go to court to defend my idea?
Yeah. Don't panic. It's highly unlikely. It's very rare, even in big industry where they have hundreds of patents. It's relatively unusual for a patent to be asserted, and even more unusual for that to lead to legal proceedings and ultimately a court judgment on the matter. So most of these things will be resolved along the way. You'll have a discussion with the person that you're in conflict with. There's various things you can do to mitigate a potential problem, and these things will either go away or be resolved with some kind of commercial resolution more often than not. Whereas the court's there as a final resort if you ever want to enforce your patent. It's quite unusual. That's where you end up.
Okay, that's reassuring. So shall we now talk about the claims section of a patent application?
We can if you like, yes.
Okay, so I understand that that's the most important part, and that if it ever does go to court, which as we just heard is highly unlikely, that actually the kind of, particularly the main claims, am I right, is the kind of critical bit that's going to get dissected and pulled apart to see whether this competitor product is actually infringing your patent or not. Is that correct?
That's pretty accurate, yes. The way you'll notice if you ever look at a patent specification, you have typically at least one. It's called an independent claim, and claim one will be one of those. So that's the one at the top, and it has it's quite broad in scope and covers the overarching concept that you're trying to protect. You then have a little chain underneath which will refer back to claim one, or if they're lower down, they'll refer back to previous claims. And what those are essentially doing is saying that's the main concept, but you could improve it a little bit if you add in this feature. So you have a little tree branching out into sort of different directions as to these are other ways to improve upon what we've already said. Your first independent claim, that is the sort of the biggest catch-all of as many competitors as possible. But what can happen if you try and assert your patent is that the first thing the other party are going to do is to come back with some prior art, and sometimes they will find some prior publications that the patent examiner didn't find, so you won't have already addressed in the examination process, and you can subsequently find out occasionally that what's in your claim 1 might look a little bit vulnerable to a potential validity challenge, which is why you have those other claims. So quite often in that situation, you would then fall back on those subsequent dependent claims with the extra features in. And ideally, if we've done our job properly, those should embrace whatever it is the other person is doing at that stage.
Okay, so if we take the example quickly of the pushchair, so we have an independent claim around the ventilation system basically within the carry coil.
Okay.
So I guess there'd be a claim that said you've got a panel at either end and the air flows through, and I think that is the kind of primary kind of independent claim on that part. Yeah. And then there's 5 or 6 other claims underneath that. So what they are is fallback positions, so that if there's a problem with the main claim, and I think what we do is we tighten up and say, I don't know, that it's a ventilation system with magnetic flaps that close it, if you don't want to use it. So if we can't, I guess, in that situation then defend the overall ventilation system, maybe we can defend a ventilation system with magnetic closure and flaps.
Exactly right. Yes, all of those other claims are potentially useful to you.
Okay, because I guess if you're going through this whole process and you're putting time and effort and money into it, and it takes several years obviously to go from initial right the way through to grant, you're going to want to make sure that you've got those fallback positions in there and you've actually got value out of your application.
Absolutely, and that again comes back to making sure you've got all the content in there at the start, because you do need to rely on that initial disclosure to put into those claims.
Is there any part of a patent that we haven't dissected yet?
Oh goodness, the abstract maybe?
Okay, yeah.
The figures. So the abstract is basically just a bit of a summary that will go on the front page of your published patent specification. It quite often refers to one of the figures, which would be maybe the most likely embodiment that you would use your invention for, and just gives the reader a little summary of what it's about, so they can decide whether it's worth reading the rest of the patent if it's of interest to them.
Okay, so I guess it's the same as an abstract in any kind of report.
Much,
it's summarising it to give people an idea as to whether they want to read the rest. And let's just talk a little bit about the figures then, just patent speak for drawings. I understand there's a particular way you've got to do those drawings. I can't include lots of nice shading and colours and photorealistic renders or anything.
No, I'm afraid not. The patent office hasn't quite caught up with modern technology when it comes to good drawings. So there are quite unnecessarily, in some people's views, rules on what your drawings should look like. So they will specify things such as the thickness of the lines, the height of reference numerals that you include in there, the size of the borders, and as you've correctly pointed out, they don't like shading or blurred lines or colours or anything like that. So ideally what you want is simple line drawings, as simple as you can, tempting as it is, because you probably already generated really clever ones that show that detail much better. But yeah, so they're very much concerned about, who knows why for these modern times, is can you reproduce it on a photocopy without losing quality of the image, which is why it comes down to the size of the numbers and things like that, and the lines. So don't have too many different thickness of lines or too many lines close together or shading or things like that. Otherwise you will get a letter coming back saying, oh, these don't comply with the rules. You can address that and deal with that and submit new drawings that address the objections, but it does slow things up and it adds a little bit to your cost.
That's great advice. Thanks, Vikki. The process is obviously quite complex and quite involved, so if someone is watching and thinking about the fact they need a patent for their idea, what would be their first step in terms of talking to you about it?
So look us up on the website, Pure Ideas, all the contact details are there. Get in touch. We don't charge from the minute you walk in the door. We'll do an initial consultation for free, just talk to you about what your idea is, what's the way to protect. It isn't always a patent, it could be designs or trademarks or just a trade secret, and we can give you advice on what we recommend, what the likely costs involved are going to be going forwards.
That's great, and we will put a link down in the description below through to the Pure Ideas website, so you can get in touch with Vikki and the rest of her team to discuss your specific idea. So to finish off, let's just talk about changes during the process, because I know one of the big challenges we had with our pushchair was that things evolved and we wanted to potentially update the patent, but from my understanding that really isn't very possible at all once you've got your application in.
No. So the way patents work is what you have in the specification at the start is all you have to work with when you're arguing with the examiner or when you're updating your claims. So you can change what's in the claims, and you can pick features out of your original specification to add to your claims, even if they weren't in the claims section at the start. But what you can't do is introduce new material, or what the Patent Office calls added matter. They are very strict on that. And even if you can get it past the patent examiner, it could come back and haunt you later, because a third party who notices that can challenge the validity of your patent on the basis of that having been added. So that works two ways. You can't write new material to put in, and you also have to be very careful about what you take out. So if you indicate something as an essential feature initially, and then take that out and say, actually, you don't need this in there later, that can also be added matter. So yeah, it's really important to know from the start what's essential, what isn't, and what's just a preferred idea. And if you develop your technology further, you might have another invention there, and there's no problem at all in having another patent application to an improvement on whatever's in your previous patent application.
Okay, that's really helpful. But I guess the key takeaway would be get everything you can into that original patent. Give all the information you've got, including other ideas or things you've rejected, to your patent attorney.
Absolutely.
So they've got the most to work with to give you the best chance of success.
Definitely, yeah. We'd rather have too much than too little information. We're not necessarily going to put every last bit of that in. We'll obviously do our best to make it as tricky as possible for competitors to be able to pick it up.
Hopefully you found that video useful. I know that I've certainly picked up a thing or two that I wasn't clear about previously. You might be wondering though, is it worth all the hassle and the effort and the time and the money to actually file a patent in the first place? If so, make sure you check out this next video straight away. Vikki and I will see you there.